Good afternoon, all those who have joined this webinar, and thank you for doing so. We are planning to unpick and unpack the current state of the law and planning policy as it applies to solar energy development in the Greenbelt. We expect the webinar to take about an hour. As you can see from this opening slide, there are 4 of us who will be speaking to you, and I'll introduce what each of us is going to cover in just a moment. We do welcome questions. We'll do our best to address them as they arise, if they relate to the talk that we're giving or at the end. But forgive us if we don't have time for them, because this is going to be quite a full session. So please, if you do have a question, use the Q&A function, not the chat. That is where we will be looking for your interesting questions. Thank you very much. So it is, as shall we say, early days for the grey Greenbelt and its effect on planning authorities, on investors, developers, landowners, all those concerned with development. And no doubt all of those people have that sense of being on the steep part of the learning curve. As barristers, we are, as you would expect, ready to argue for or against any particular scheme on any particular site. We exist in order to help you make the best case possible for development, and you make the best case possible against the development. However, for the purposes of this webinar, we're here for the single purpose of sharing some of what we know and conveying to you the significance of recent and imminent changes of law and policy. So I will start by taking you through the recently revised Greenbelt policy framework, hopefully setting you up for the talk from Richard Ground, KC, who will provide a necessarily fairly concise summary of recent decisions and case law relating to solar development in the Greenbelt. Sam Fowles will follow, sharing some tips for those working on solar projects at the moment. And finally, Lois Lane will look ahead to those imminent changes, which may just make the difference and drive solar energy production through the roof. For one thing has been clear, since the Johnson government introduced the 70 gigawatt 2035 target, and we were only at 15.8 gigawatts in 2023. There is a demonstrable national need for more solar development. And if you were in any doubt as to the Labour government's continuation of the drive for solar, if anything, they have ramped it up. One of the first things they did was to grant development consent orders for 3 solar NSIPs and to reactivate the Solar Task Force as part of the government's effort to speed up delivery of solar energy across the country. So it couldn't be a more apposite time after the Greenbelt policy changes to look at the place of solar development in the Greenbelt. And I'll waste no more time in starting on the subject of navigating the Greenbelt policy framework. Next slide, please, Will. Thank you. So that's just the heading. And if we can go into the first slide, thank you very much. So the first thing to ascertain is which regime applies to the particular project you're considering. And just a note that Lois will be covering in due course the government's intent to raise the threshold for NSIPs from 50 megawatts to 100 megawatts, and the consequences of that will be interesting. My task is to consider whether the difference between a Planning Act proposal and a Town and Country Planning Act proposal, so whether you're inside or outside the NSIP process, whether that makes a difference to the relevant policy. And so far as we can tell, very little difference, if any, because the national policy statements, EN1 and EN3, on Greenbelt issues, both take the reader back to the NPPF. So this, with the recently published PPG, effectively sets the Greenbelt policy framework for solar development, whether it is within the Greenbelt, whether it's an NSIP or a planning act, a town and country planning act application. So having established what the relevant policy framework is, the critical question, isn't it, for Greenbelt development is whether your development is appropriate development in the Greenbelt. That depends, for solar development, on the answer to two questions. First, is your Greenbelt grey? In other words, does it fall within the new definition of grey belt incorporated within the NPPF? And if, and only if it is grey, are the paragraph 155 tests met, the new category of appropriate development in the Greenbelt? And then, having established whether the development is appropriate or not, we know where we stand on Greenbelt policy if it is not, if it is inappropriate, if it is not appropriate development in the Greenbelt. If it is appropriate, does the NPPF provide us with a presumption in favour of permission? No, what it does, as I will go on to show, is make the Greenbelt constraint a neutral one. It neither helps nor hinders the progress of the project. So looking at the at that two-stage test, please could I have the next slide, as we will consider how we assess whether the Greenbelt in the relevant location is grey. The Greenbelt is grey if it comprises, and this is the emboldened part of this definition, previously developed land and or any other land that in either case does not strongly contribute to any of purposes A, B or D in paragraph 143 of the NPPF. So just looking at that in a little more detail, why does the definition refer to previously developed land at all? It isn't a fast track to being grey belt. Whether or not you are brownfield land, whatever the quality of the land is, if it doesn't strongly contribute to one or more of those purposes, A, B or D, then it is grey belt, subject to the qualifier at the end of the glossary, to which we will come. We'll look at those three purposes in a little more detail in a moment, but just to run that past you again, because there's so many double negatives, provided the land contributes strongly to one of those purposes, it is not grey belt. So look at the qualifier within that glossary. Excluded is land if the application of the policies related to the area or assets in footnote 7, other than Greenbelt, would provide a strong reason for refusing or restricting development. You're familiar with footnote 7. It arises in paragraph 11, and it relates to the presumption in favour of sustainable development. And the adjective strong there is also found in the footnote to paragraph 11 as well. Not sure, this is one thing we should look out for, not sure whether that adjective strong really adds anything to the qualifier there, the exclusion of land where footnote 7 policies would provide a strong reason for refusing or restricting development. Next slide, please. So looking, drawing from that last slide, that two-stage process, you consider contribution to purposes and then whether there's an exclusion. Let's look at contribution to purposes in a little more detail. I've set out those 3 of the 5 purposes here on the slide, and you'll note that there is no reference to purpose C, to assist in safeguarding the countryside from encroachment, and no reference to purpose E, to assist in urban regeneration by encouraging the recycling of derelict and other land. So those purposes, which are so often used to justify the designation of green belt in rural areas, relatively far from large built-up areas and towns, those are absent from this first step in identifying grey belt land. And I've taken from this definition and this first step in identifying grey belt land 3 points from the PPG. So you'll already be aware that this is a question of judgment, absolutely. But we have now in the PPG some fairly detailed, at paragraph 5, some fairly detailed illustrative features of a strong contribution. So the PPG divides the potential for a contribution into strong, moderate, and limited or weak or none. And to get into the category strong, there are a list of illustrative features. Well, the role that those will play in decision making will need to be watched carefully. Second, have a look at the way that the PPG refers to assessment areas. These are identified by the planning authority when undertaking a green belt assessment, which the PPG advises them to do so, at a relevant point, to use the language of the PPG. Green belt authorities may think it's important to get going on a green belt assessment anytime soon. But until a green belt assessment has been adopted by a planning authority, it is the contribution of the site that is assessed. And it doesn't take Einstein to see that it's far harder for a site alone to be considered to have a strong contribution to any of those 3 purposes than it is for a wider area. How those assessment areas are identified and how robust that makes the green belt assessment ultimately adopted will be something to watch. Finally, and simplest of all these 3 points, villages are not towns or large built up areas. Next slide, please. The grey belt exclusion. I can take this quite quickly. As was clear from the points I made earlier, a site or assessment area does not make a strong contribution to those purposes if I'm so sorry. If a site or assessment area does not make a strong contribution, then it may be grey, but not necessarily. And we have the footnote 7 policies. If they provide a strong reason for refusing or restricting development, then they are excluded. Where areas of grey belt would be covered by or affect other designations in footnote 7, it may only be possible to provisionally identify such land as grey belt in advance of more detailed specific proposals. If you've been reading the PPG, you may be a little curious about this. I certainly am. What this suggests is that because the local planning authorities will be undertaking green belt assessments, and because of this exclusionary part of the definition, there will be parts of land that they think may be grey because they don't contribute strongly to those 3 purposes, but nevertheless they are perhaps in the setting of important heritage assets or perhaps affected by those environmental designations, in which case it appears that the government expects a provisional identification of land as grey belt, something that I in particular will be watching very carefully to see how that is dealt with in those assessments. Of course, we don't have any assessments yet to see how it's been navigated by others. Next slide, please. So personal reflections on this point, which I'll take very quickly. This might affect large swathes of rural land and means that the greenbelt status of the land, which dictates the policies applicable to the development, effectively whether that paragraph 155 route to appropriateness applies, that greenbelt status depends itself on the acceptability of detailed proposals. So as I said, I find that quite curious. Next slide, please. So if your site is grey belt, so what? Well, we have the new, as I indicated, paragraph 155 route to a finding that the development is not inappropriate. That is to say, it is appropriate in the greenbelt. 3 of the 4 tests need to be applied. That is only because the 4th test, the golden rules, doesn't apply to solar development. So all of the 3 tests that apply must be met. The first, it would not fundamentally undermine my emphasis, quite a high bar that, but one, just refer you to Richard's in advance, heads up that Richard will be talking about an appeal decision in which permission was granted notwithstanding fundamentally undermining the purposes of the remaining greenbelt across the area of the plan under very special circumstances. So fundamentally undermine is a high burden though. Second, demonstrable unmet need. Third, sustainable location. Putting it shortly, you might agree with me that both of those are relatively easy to prove in relation to a solar development. Next slide, please. So having identified that the land is grey and identified that the development is appropriate, so what? Well, as I indicated earlier, there's no presumption in favour of the development, but as the PPG makes clear, openness and purposes will be deemed protected or met, so openness protected, purposes met for Greenbelt policy reasons. In other words, the Greenbelt policies become neutral in the planning balance insofar as site-specific impacts are concerned. Other policies, such as those protective of the landscape character, they will continue to apply, and they may require consideration of the impact on openness, but that Greenbelt policy constraint goes away. Those are my thoughts on navigating the Greenbelt policy framework. I'll hand over to Richard. Thank you very much.
Thank you very much, Harriet, for setting out the policy framework so clearly. I don't know if many of you will know, but that's Harriet's last ever webinar as a junior barrister, because next Monday, we're all delighted that she's going to take silk. I didn't tell her about this, but I was embarrassing her. So can I have the next slide, please, Will? I'm going to talk about 4 greenbelt cases for solar arrays and batteries to cover the lessons from them and how inspectors are applying this policy that we have before us. The first 2 are grey belt arguments, and cases 3 and 4 will be very special circumstances arguments. So the first decision I'm going to talk about is the Kenilworth decision. And you might think sensibly, the developer run their greenbelt argument in 2 different ways. Firstly, they said that their solar array and battery was appropriate because it met the grey belt definitions and the 155 tests. So that's the appropriateness argument. And they secondly ran their argument on very special circumstances. Now, clearly, we've had, I think, about 60 appeal decisions on the grey belt, and it's a very fast emerging area. But in terms of solar arrays and batteries, there are way fewer decisions. So I've concentrated on the ones for solar arrays and batteries and done a Compass search. So I should have had a fairly comprehensive list of them. Could I have the next slide, please, Will? Thank you very much. We get to step one in this Kenilworth decision, and step one is whether it complies with the grey belt definition. And Harriet's already set it out, but it complies with the grey belt definition if it doesn't strongly contribute to that purpose A, B, and C. So if it doesn't contribute to any of those purposes strongly, it will be appropriate development. And what did the inspector do with this in this Kenilworth case? What the inspector did was he first of all said that in terms of checking unrestricted sprawl, that because the development the site was a long way from any large built up area, that it didn't contribute strongly to that purpose. In terms of purpose B, preventing towns merging, the inspector said it was quite a distance from the towns, so that it didn't strongly contribute to preventing towns merging. And in terms of D, there was no point taken about any historic town. So what the inspector did in a nutshell was to say that the definition of grey belt was satisfied because it didn't strongly contribute to any of those three purposes. And since that decision came out, the PPG has been published. And what the PPG says is it confirms that the inspector was right in his approach in terms of dealing with checking unrestricted sprawl and whether a site strongly contributes to that, because the PPG said that where it's adjacent to a large built-up area, that will be a strong contribution, and where it's not adjacent, that will generally be a weak contribution. And so far as solar arrays are concerned, it will very often be the case then, following the PPG guidance and this decision, that it will be quite possible to show that the site doesn't have a strong contribution to checking unrestricted sprawl. Next slide, please. Well, I feel like Chris Whitty. And then the inspector moved to the second test. He found, as we've seen, that it met the definitions of grey belt. And then, of course, it's necessary to apply all these 155 tests to be appropriate development. A development has to pass all of these to take out all the negatives. So I know that one of the questions from Mr. Bainbridge was whether whether it was significant that purpose C was excluded from the definition of grey belt, and it's very significant. But this inspector effectively brought back in purpose C, which is safeguarding the countryside from encroachment, in applying 155A. So 155A says the development would utilise grey belt land and would not fundamentally undermine the purposes taken together of the remaining green belt across the area of the plan. And what the inspector said in this Kenilworth decision is that involves you looking at the two purposes that had been forgotten, which is safeguarding the countryside from encroachment, and purpose E, which won't very often arise, so I'm not going to focus on that. And what the inspector said in this case was, because it was an extensive tract of land, and the land currently makes a strong contribution to that purpose, i.e. purpose C of safeguarding the countryside, he said that 155A was not complied with, and so that it couldn't be appropriate. And I think that's going to be probably one of the more sticky tests to pass, because obviously solar arrays quite often are going to have an effect on encroachment of countryside if they're away from settlements and towns. Although the test, what remains to be seen is how much that test will make it difficult to say that, because it says it would fundamentally undermine the purposes taken together of the remaining greenbelt across the area of the plan. So it's probably got to be a impact which is quite substantial on that purpose of safeguarding the countryside from encroachment, and not only on its site, but on neighbouring sites as well. But so that was an area where it's a risk for promoters that you effectively have to look at purpose C through that A. And then if we could go to the next slide, please. But in terms of being positive about the 155 tests, you'll see from this slide that all of the other 3 tests were readily passed for that Kenilworth development. Existing in urban regeneration wasn't breached because solar farms are unlikely to be suitable in urban land. The unmet need, the inspector said was passed, and 155C, sustainable location. And many of these decisions we'll see, again, what the inspector said was that that wasn't of great relevance because effectively this doesn't create many movements. And as a result, they said that that was passed because there was no highway objection. Next slide, please. So the inspector then, because effectively the first 155 test wasn't passed, the inspector then said it wasn't appropriate development, and they had to move on to very special circumstances. The observations on harm in that case were that there was an impact on spatial and visual openness. It wasn't a national landscape. But what's noticeable is that the benefits that were prayed in aid and accepted by the inspector was that there was substantial weight to the urgent need to generate and store renewable energy in support of the national imperative. Now, I see on the questions, some people are questioning the need on the basis that the supply of solar farms has got very substantial now. Clearly, in none of the appeal decisions that I've seen has that argument been accepted, but there will come a time maybe that that it will be worth exploring that argument. But none of the appeal decisions that I've seen have taken that point, and still has taken it successfully. But obviously that remains to be seen on the evidence in any particular case. But the benefits that that inspector accepted are pretty repeatable, and the specific points in that case were that it met the objectives of the local planning authority, which the inspector gave significant weight to, and that there was a grid connection offer. Now, I think all of the successful cases in the Greenbelt have a grid connection offer. I mean, it is, and so that, but providing that's the case, it's noteworthy to my mind that the Greenbelt has traditionally, over the last 25 years, when I've been practicing, been seen as a very stringent protection. But nevertheless, for solar farms, inspectors have been willing to say there's very special circumstances. Next slide. And then I moved to a battery storage case. And there were 2 points that were argued in this battery storage case in Carrington. I've given you the reference, and you'll get the slides afterwards. And then, of course, you can find the appeal decision from that reference. The 2 points that were taken is, of course, that it was appropriate development as it met the definitions of the grey belt. And secondly, it passed the tests in 155. This was a 35 megawatt battery storage facility. And then next one, please. And we'll see how Carrington got on. Essentially, it was a relatively small site. So what the inspector said is, because it was limited in size and it was remote to the large built-up areas, it passed the test in 143A because it didn't make, it only made a limited contribution to 143 unrestricted sprawl. Neighbouring towns merging, again, because of the distance to towns and the remaining gap It passed that test, didn't make a strong contribution to that purpose, and 143D didn't apply. So the inspector concluded that it met the tests of grey belt by only making a limited contribution to those purposes. And the next slide, please. And then we get to step 2 in this, and effectively that's whether it passes the 155 tests. And what the inspector said is it didn't undermine the purposes taken together. In terms of purpose C, which is protecting the countryside from encroachment, the inspector said, well, it was a limited geographical spread, and there were adjoining commercial activities in that case. So the inspector concluded that purpose C didn't fundamentally undermine the purposes taken together. So that's the first bullet point. 155A was passed. Again, this inspector accepted there was a demonstrable need. He relied on the NPPF and EN1. The sustainability test, again, this inspector said it relates to other types of development, really, that sustainability test. And he said it was passed because there was no objection from highways, because basically there's very limited amount of movements for this case, for this type of case. And the golden rules about affordable housing and so on didn't apply. And then, as Harriet's already said, and this inspector followed that approach, where it's appropriate development, the courts in Lee Valley have found that it's not harmful to the greenbelt, and that's consistent with the framework at footnote 55 and the end of the PPG on greenbelt that's just been published. Next slide, please. Thanks, Will. And then I turn to the first of the very special circumstances case. I'm going to take these relatively quickly. And again, much of the very special circumstances which were found to exist in this case between paragraph 107 and 111 are factors that are quite repeatable. So it may well be that developers in this area will put forward lots of appeal decisions which all help to reiterate that. What the inspector found is that there was an urgent need for renewable energy and to enable energy security, and gave that substantial weight. The only real bespoke specific benefits in this case was a biodiversity net gain of 85% for hedgerows and 137% for habitats, and a grid connection offer that has been secured. But again, those factors which the developer could do there on farmland are, you might think, pretty repeatable on other sites. And so what the inspector concluded in Wickford is that that was sufficient for very special circumstances to exist, because those benefits significantly outweighed the moderate harm to openness, both spatial and visual, and the landscape harm and the less than substantial harm, LSH, less than substantial harm to a grade 1 church. So that balance is one that the inspector drew in favour of granting under very special circumstances, and you'll see many of those factors are repeatable. And then the last case I take you to on very special circumstances for solar farms in the Greenbelt is the next slide, if that's okay, Will. And this is the Secretary of State decision pretty soon after this government were elected, and it was a decision of Matthew Pennycook of the 23rd of July. It was solar and battery, and what the Secretary of State decided was that the benefits, they gave substantial weight to the need for renewable, recovery of soil, and efficient use of land. And again, all of those three are reasonably repeatable in other solar farms cases. And the particular factors there of grid connection that could be used quickly, which got moderate weight, and the BNG of 135%. Again, are specific factors there, but that may well be able to be repeated in other cases. And all of that, those benefits, there were other benefits, but I don't go through them comprehensively, but you'll see it when you find the decision, is that was all sufficient to outweigh the harm to greenbelt, openness, spatial and visual, and the harm to one purpose, which was protecting the countryside from encroachment. And it's a Secretary of State decision. So that is a consideration of some weight, being a Secretary of State decision, and with those balance of factors, which there may well be similar cases in the future. And then my very last slide and is a case law. And I know Harriet's already mentioned it and Lois is going to mention it, but the 50 megawatt limit is going to be increased to 100 megawatts. But this case basically said, and the caution is that authorities have to be careful, and appellants have to be a bit careful when inviting authorities to permit schemes where it's very close to the limit, and there are more panels than are required to get to that limit, because the court quashed this decision because effectively what was asked for is to approve more panels than were required for 50 megawatt solar farm. And the court said, well, that hadn't been considered properly by the authority. So that if you are close and the amount of panels make an authority suspicious, or a developer has to be a bit careful about promoting too many panels for the limit. But it's a very extremely detailed case, and I probably haven't done it full justice. But if you are in that situation, be careful. So those are my lessons from the cases of inspectors and the Secretary of State and that one case in the courts. And I now hand over to Dr. Sam Fowles for some practical guidance.
Thank you, Richard. I'm going to slightly change gears a bit here, because I'm very grateful to my colleagues in that they gave me the really easy job of, rather than having to do the hard graft that they've done of looking and deeply analysing cases, they're letting me talk about a few of my own cases and a few of the lessons that I learned from some appeals in the Green Belt concerning solar farms that I've done recently. In view of the time constraints, I'm going to do the following. Will, can I have the next slide, please? This is going to be Sam's top 5 tips for solar farm applications, and I'm going to be focusing not so much on the policy concerns, but on the practical concerns of presenting a case one way or another. I've tried to pick top tips that are going to be useful for both sides of the equation, whether you are a developer or a local authority, or indeed a Rule 6 party who's a part of the local community. So, my top tips. Top tip number 1, Will, if I can have the next slide. Location, location, location. This was really brought home to me in a matter that I dealt with a couple of years ago now, and I should just say what I'm not going to do is actually identify these matters, because if I'm saying, well, this was a bad tactic or this was a good tactic, I don't want to sort of be hanging that around anyone's neck in particular. So this is all I'm going to admit is that I was involved in these. I'm not even going to admit which side I was on. Here's the location, location, location. This matter involved a solar farm. It was in the Greenbelt, but it had 2 crucial issues. One, it was right next to an area of outstanding natural beauty. And 2, the developer had picked an area of land that was basically sort of V-shaped like that. And it was going to be, the plan was to put the panels on sort of the inside of the V. Now, this engaged various different things, but crucially impact on the AONB but also visual impact on the greenbelt more generally, and spatial impact on the greenbelt more generally. And by choosing this site, this V-shaped site, the developer basically gave themselves the worst of every possible world, in that they doubled their visual impact because you could see it from every side. They doubled their spatial impact, again, because it was incredibly prominent from every side. And they also managed to situate it right into in an area where you were looking in to the AONB. So it wasn't a massive farm. It was about 32 hectares. It was very close to grid access, and I'll come mention that in a second. It had a huge amount of things going for it, and had they just picked a flat field, even in a similar sort of area, then it's likely that this would have received permission. But by choosing that really unfortunate location, they just gave themselves a mountain to climb. The other point I wanted to pick up on this slide was grid access. And I'm sure everyone, certainly on the developer side, will be acutely aware of the issues with grid access. It's in some situations it takes up to 10 years to get a grid connection, and so whether or not it's easy to plug these things into the grid to get a good grid access is likely to be a significant concern, and it has in fact come up in pretty much every one of these that I've done, as a factor that mitigates in favor of the development, and contributes to VSC. And so giving very careful thought to grid access is also going to make a difference. What you can't do, and what didn't work, and was the argument that well, grid access can be reduced as a VSC, because essentially you could put this solar farm anywhere in relation to grid access and still receive still make the same contribution to the various environmental goals. And in one matter that I dealt with, one side actually identified a bunch of different bunch of alternative sites, but they weren't in the locality. They were identified based on where is there likely to be sufficient grid access elsewhere in the country. And that was argued on the basis that, well, you'd be making the same contribution to renewable power across the country as a whole, basically wherever you put it. And because the grid is not localized, so if, say, you're in Cheltenham, you could be drawing on power that is being generated in Dundee, or you could be drawing on power that's generated in Evesham. It doesn't matter. It all goes into the same grid. The argument was put that, well, if you're looking for alternative sites, then you have to basically do a nationwide search. That did not convince the inspector at all. The inspectors acknowledged, yes, that is correct as a matter of fact, but essentially, if you still have to look at the locality, the local area, when looking for alternative sites. I'm conscious of the time, so this is going to be a bit of a whistle-stop tour. So let's jump onto the next slide, please, Will. Thank you. This is a connected issue, which is that size is important, and size is often determinative. It can be the difference between having a really, really easy ride and a really, really tricky time. If we go back to the V-shaped farm, had they made the farm slightly smaller, they could have hidden it within the V, and essentially, most of the issues around AONB, around visual impact, around spatial impact would probably have gone away or carried very little weight and tipped the balance in their favor. Of course, if you're a developer, you're dealing with economies of scale, so you want to develop farms that are as large as possible, because then you're benefiting from economies of scale. However, the bigger they are, the larger the impacts, the more likely they are to antagonize the local community. And so the more likely you are to get responses from Rule 6 parties. And so it's a difficult balance to draw. In my experience, it's much easier to tip the balance against a large farm than it is a small farm. But and policy is often going to make a big difference as well here, because local policies are likely to express a preference about the size of farms, and it may be the difference between essentially something being waved through and something going to a long drawn out process. Can we jump again, please, Will? Now, this was a really interesting issue that arose and comes up in pretty much every one of these that I've done. I've included broken my rule here and included an extract from the Little Heath Lane decision. Now, obviously, in the strictest sense of the term, solar farms are not permanent. They're going to be sticking around for 40 years or so, maybe a bit less. And every developer that I've either been for or against has argued the point, well, this is a temporary development, and so the impacts and the weight given to the impact should be reduced accordingly. And this has always gone relatively badly for the reasons that are set out in this on this slide. I think the tactical issue here is that if you try to sort of, duck the issue effectively by saying something's a temporary development, well, then you actually put yourself at a disadvantage from a developer's perspective, because you've argued something that is not really going to be accepted by the inspector, rather than grasping the nettle. So my top tip is just to accept that the practical impacts are going to be akin to a permanent development, and analyze it in that way. Grasp the nettle as a developer. Flipping to the other side, if you're a local authority, again, you don't need to accept that this is a temporary development. They are generally, in my experience, analysed as permanent development, because the impacts will be experienced as permanent by the majority of those involved. Next one, please, Will. As we all know, looks count for a lot. We should judge a book by its cover, and we should particularly judge a solar farm by how it looks. Now, the reason I brought up this is that in a particular development that I dealt with, there was a significant number of views, not from close by. Actually, if you were nearby, you could barely see it, but there were views onto it from across a sort of a ridge on the other side of the valley, and from various different, essentially, hiking spots. Now, what the promoter of this matter did was invested quite heavily in CGI mock-ups of what it would look like. Now, unfortunately, and those CGI mock-ups showed the panels as greenish, and so kind of blending into the land. Now, in reality, panels don't look like that. And so what we were able to do and I was for the other side, the local authority in this matter, was just simply show photographs of equivalent panels, which reflect the sky most of the time. And so when it's nice, they look blue. When it's overcast, they look sort of bluey grey, and so stand out much more. And you had a party that had invested a lot of money in putting this evidence together, and it just didn't land because it's essentially a few photographs printed off with a laserjet printer kind of undermine the entire thing. So my advice to developers is sometimes it's actually better to go low tech when you're trying to show what these things will look like. Show photographs of equivalent panels. rather than sort of investing in a high-tech CGI mock-up that actually might be undermined. And again, for councils, is to look at what the actual panel that is proposed will look like, and that's the key thing, because not all solar panels are the same. Go and look at other examples of what the panel that's proposed look like, and put those in front of the inspector. There's a few more bullet points, but I'm going to jump again. Fifth top tip: it's the policy, stupid. I was trying to get a Bill Clinton quote into there. I think this was possibly a slight bit of a reach for a Clinton reference, but we did our best. Now the anecdote from this is a matter in which the local authority kind of came a cropper, actually, because they had a they refused permission on the basis that, well, the authority has a preference for rooftop solar. And the inspector said, well, yeah, that's all very well, but the extent of your preference is a couple of lines in your policy saying, well, we quite like rooftop solar and ideally we'll go for that. If you are a local authority, having a policy preference requires actually setting out how you're going to achieve it. And in this case, there was actually a huge potential in the area for rooftop solar, but it was a potential that just simply hadn't been identified in the policy. This sort of doubled down a little bit in that the authority lost on the urban regeneration purpose of the green belt, because the inspector said, well, I appreciate that this, in theory, it could be there could be an urban regeneration benefit in this matter, but actually there's nothing in the policy to suggest that you're going to be able to use brownfield sites for solar development, and so I'm not going to give it any weight. So for authorities, when policy making, there needs to be if you're going to go for a preference for rooftop solar, and you're going to rely on that preference to refuse ground-mounted solar, there's got to be a genuine plan in the plan, so to speak. For developers, the converse applies. If you're being refused because of a preference for rooftop solar, well, again, ask, is it a realistic preference? That sounds 5 very, very quick top tips. There are a few more bullet points, and I'll do the thing that we always do and say I refer you to my written submissions. And handing over to Lois, who has got her crystal ball out and is looking into the future.
Thank you, Sam. So just a few points looking ahead over the next months and years. And Will, if we could go straight ahead to the next slide. Some of these relate directly to Greenbelt, but most are more general in terms of solar changes in the pipeline. Now, the first is something that's been touched on briefly already by Harriet and Richard, and relates to the threshold for solar projects to become NSIPs. And as I'm sure you'll all be well aware by now, that is increasing. And the mechanism for that is the Infrastructure Planning Onshore Wind and Solar Generation Order 2025. It's going to come into effect at the end of the year, and that will increase the threshold for projects to come out of the TCPA regime and into the Planning Act regime from the current 50 megawatts to 100 megawatts, but notably not to the previous 150 megawatts that was consulted on by the government. And that's probably because other types of generating stations in the Planning Act in Section 15 are 100 megawatts, and it's probably a standardization issue that it didn't make sense to have a separate threshold for solar. There are in that order transitional provisions for projects that are already in the Planning Act system, but in practice that's largely a theoretical set of provisions, because I'm at least not aware of any solar projects currently in the NSIP system between 50 and 100 megawatts. I'd certainly be interested to hear if any of the attendees have come across any. There would have been a couple between 100 and 150 that would have been caught if that had been the threshold, but there's not, to my knowledge, any between 50 and 100. And then moving on to the next slide for why this threshold has been increased. Well, it's targeting the current planning dead zone of projects between 50 and 100 megawatts. As I'm sure those of you dealing with applications and making them are well aware, there's currently a real clustering of projects at the 49.9 megawatt mark, and we can probably expect to see a similar clustering from next year of 99.9 megawatt projects, projects trying to take the maximum advantage of how much generating capacity they can get out of the TCPA regime without having to tip over into the Planning Act regime. So we'll perhaps see less of the fields like the top one and more of the fields like the bottom image in that slide. And moving on, we also have clause 3 of the Planning and Infrastructure Bill, which was published last week. And this clause would be potentially quite a big change in terms of solar, in that it's proposing to insert a new section 35A into the Planning Act, and that's a complement to the current section 35. Section 35 currently gives the Secretary of State the power to bring projects which don't meet the thresholds for an NSIP within the NSIP regime, so that developers can in effect invite the Secretary of State to elect on a case-by-case basis to treat their project under the DCO application process. This new section 35A would allow the converse to happen. So it would allow promoters of major solar projects to, on a case-by-case basis, invite the Secretary of State to allow them to seek permission through an alternative consenting regime, and in particular through the TCPA. So we can expect to see some larger projects attempting to opt out of that regime, and we might find that particularly in cases where there are no CPO powers required, that's likely to be an attractive option. What other changes are we likely to see? And well, if we could go to the next slide. Well, grid connections. We've had a question about this in the chat about whether or not we really need to be scaling up solar permissions when actually the capacity in the pipeline for a grid connection is more than the 70 gigawatts that are required for the targets, the national targets. And part of the answer to that is that there's a real problem at the moment with so-called zombie projects which are in the queue for a grid connection, but where they're either at an early stage of development, some preparatory work has been done, but perhaps not much. There's maybe issues around securing land, and with the current national grid or national system for prioritizing grid connections, it's a first come, first served system, and that doesn't take into consideration what stage of development a project might be at. So the National Energy Systems Operator, NESO, and Ofgem are currently consulting on a proposed change from a first come, first served system to a first ready, first connected system, i.e. one that would allow licenses to be amended such that projects which are further on in development can be prioritized for a grid connection. And this Chapter 2 in the Planning and Infrastructure Bill puts that on a statutory footing, essentially. So it would give the Secretary of State 3 years from royal assent to prioritise grid connections by directly amending electricity licenses to allow, like Homer Simpson in this lovely gift, to allow developers who are at a further stage in terms of physical preparation of the project to jump the queue and to get connected sooner. So it is true that there is a real issue with grid connections, and there is a lot of capacity in the system that is not currently coming online because of grid connection issues. However, one thing to say in terms of that question about permissions and the pipeline is that we do, of course, need to secure that pipeline beyond 2030, beyond 2035, we need to be thinking about solar permissions, that they're time limited, they tend to be 40-year permissions, and when those expire, what's the legacy planning after that? This is an issue where we'll need to be thinking about ensuring that there is a pipeline going on into the future beyond just those immediate generating targets. And moving on then to the next slide. What other reforms might we see that were included in the working paper that was published by the government in January, but haven't yet come forward in the Planning and Infrastructure Bill? Not many is the answer. Most of the stuff in that working paper is in the Planning and Infrastructure Bill. But one thing that was addressed in the working paper that hasn't yet come forward in a legislative capacity is around potential flexibility in the DCO examination process for solar projects. There are changes proposed to the NSIP consultation process generally around allowing the Secretary of State to take a wider range of matters into consideration, but the working paper talked about allowing the examining authority in a solar DCO application to, for example, combine different stages of the process to try and speed up that process and to ensure that solar DCOs can be treated more quickly, because they tend to be, on the whole, a little bit simpler than certain other types of DCOs, because they're, for example, not major issues around traffic, or they just sort of sit there and generate power. So there are fewer moving parts to consider. So watch this space. We may see more legislative movement on the actual DCO examination process in due course. Next slide, please, Will. And then overall, what can we expect to see? Well, as I think you've probably gathered from all of the speakers, we can expect to see a lot more solar farms everywhere, and that includes in the Green Belt. Can we expect to see NSIP scale solar farms in the Green Belt? Quite possibly. It's certainly a possibility, especially in possibly the rare situations where you have a really significant amount of previously developed land within the Green Belt. We could certainly see DCO applications coming forward for those sites. We are also likely to see perhaps disagreements between planning officers and elected members. And we've had that very recently at a site in North Yorkshire near Selby, where officers recommended approval for a 49.95 megawatt solar farm. Elected members decided that they disagreed, and they disagreed partly on Greenbelt grounds, and they disagreed partly on grounds that the site in question included a lot of best and most versatile agricultural land. And we're likely to see a lot more arguments about best and most versatile agricultural land. Very recently, just at the end of February, Richard Fuller, who's the MP for North Bedfordshire, wrote to Ed Miliband inviting him to clarify whether government policy around best and most versatile agricultural land and solar had changed. And Ed Miliband confirmed that no, it hasn't. It's still as it stands in EN3, the national policy statement in relation to solar, that the government prefers solar to be on brownfield sites, previously developed land, contaminated land, and then that lower agricultural quality land is preferred over best and most versatile, and that should only be used where necessary. But necessary is a flexible concept, and we are almost certainly going to see more arguments about whether or not we should be prioritising food security and best and most versatile, or energy security and the need to speed up solar delivery. So watch this space. We can expect to see lots of arguments about this over the next few months and years, and we can certainly expect to see a lot of 99.9 megawatt applications coming in starting on the 1st of January 2026. So thank you very much. I think we've got a final slide, and I will hand back to Harriet. We may or may not have a little bit of time for questions.
They're unmuted. Sorry for that. Thank you so much, Lois. A lovely note to end on. As you see from this slide, we reckon we've got the Greenbelt wrapped up so far as anyone knows about it at the moment. But that there is a lot that will come out in subsequent months, weeks and months, as we see this policy framework bed in. Thank you to all my fellow speakers. Thank you too to Mark Woodger, who's put on the Q&A that I think that's Essex County Council has been asked to consider a 98 megawatt solar farm. So Lois's crystal ball, as referred to by Sam, is proving prescient already. So very interesting times in terms of delivery of solar, and in terms of the opening up, the relative opening up of the green belt, where it is grey, and as we've heard, particularly interesting for solar development. There are still one or two unanswered questions in the Q&A, but since we have overrun, I'm going to do what I can to answer those in writing and round up this webinar with many, many thanks to, as I said, my 3 co-speakers, and to all those who attended and raised such interesting questions. Thank you.